Professor Lucinda Finley is the Frank Raichi Professor of Law at Buffalo Law School, and she's taught in tort law, in women in the law, reproductive rights, employment discrimination, First Amendment. She's the author of numerous law review articles, as well as being a litigator in the federal courts. And she's also testified frequently before the United States Congress and state legislative committees. And she's the first female lawyer from Western New York to argue a case before the United States Supreme Court. She is also an avid equestrian and frequently competes in equestrian shows where I'm told she has to sign the arbitration waivers for competing in these equestrian shows. So please welcome Professor Finley.
Thank you, Carl. Yes, as he said, I know boilerplate all too well. And thank you, Ralph Nader, and everyone on his staff who's worked so hard to put on this amazing 4-day event on crucially important topics. I'm very honored to be part of today's very important discussion that has looked at the ways in which tort law helps expose unsafe practices, improve safety, bring compensation, healing, and justice to injured people. But unfortunately, I'm here today to talk about legislative developments that undermine all of those very important functions of the tort system. The so-called tort reform movement that over the last few decades, culminating and peaking from the mid-1990s through mid-2000s, now has led almost 2/3 of the states in this country to enact various types of laws that make it very difficult for injured people to get fair access to the civil justice system, or dramatically curtail the amount of recovery they can get for devastating injuries. The so-called tort reform laws were prompted by peaks in the insurance market, what's called a hard or tight market, where at various times, largely due to interest rates and global market conditions, insurance lines, such as medical malpractice insurance, got very expensive and harder to obtain. And whenever that happened, lobbyists for physicians groups, business interests, and others would go to legislatures and, of course, blame it all on injured people, their lawyers, and the tort system, and would use these periodic market-driven crises in the insurance markets as an excuse for trying to curtail tort law. And the variety of statutes passed at this time are known as tort reform. But as I intend to explain to you today, they really properly should be called tort deform. The most common type of legislative so-called reform has been to put caps or limits on the amount of non-economic damages that people can recover in certain types of cases, predominantly in medical malpractice cases, although some states have put on caps for any type of tort claim. And usually under these cap laws, the recovery is limited for these so-called non-economic damages to either $250,000 or $350,000. Usually the caps never get raised and they're not indexed to inflation. Now, what are non-economic damages, you might ask? Well, they're basically all the damages that you can recover for everything but your medical bills and your lost wages. They compensate people for things like trauma, pain, depression, overall harm to mental health and well-being, impaired quality of life, damage to your sexual functioning, ability to engage in or enjoy intimate relationships or communing with loved ones, harm to your reproductive capacity. Indeed, many people would consider these aspects of life the most priceless. And yet the impact of these caps on damages for them has been to render the priceless virtually worthless. Now, although they're called tort reform, the caps really have not had a reforming effect at all. In fact, the verb to reform means to change something in order to improve it, to make it work better. Well, after a few decades of experience with these damage cap laws, I think we can fairly now call them tort deform. The word deform means to distort, to warp, to make misshapen. And I think when we look at the pervasive, unfair, and unjust impacts of these caps, we can truly say that they undoubtedly earn the epithet tort deform. So let me give some examples of how these cap laws are in fact tort deform and how they harm particular types of people, notably women, sexual assault victims, children, and the elderly, but in fact harm all of us as members of society. Let's consider some actual types of cases and scenarios that have been affected by caps. A 15-year-old teenage girl in Ohio goes to seek counseling from her pastor. We heard all about these priest abuse cases earlier this afternoon. Well, during one of these so-called counseling sessions, she is raped twice by her pastor. And it turns out the church that employed this predator had received numerous complaints in the past about his prior inappropriate contact with younger female parishioners, and they'd ignored them. So she sued not only her rapist, but the church for negligent hiring and supervision. The jury awarded her $3.6 million in damages. Now, because as a 15-year-old at the time of the injury, she really didn't lose any income, and the medical bills, fortunately, were low. I mean, her physical injuries were not life-altering. The verdict was almost all for this non-economic category of damages. Now, this happened in Ohio, which happens to cap tort recovery in all tort cases except catastrophic physical injury to $250,000. So, after the jury said she deserved $3.6 million, the court had no choice but to apply the cap, and her total recovery was reduced to $350,000. And of course, once fees and costs will be deducted, as she has said, she will barely have enough left to afford the long-term counseling that she desperately needs. The church, of course, with this mere $350,000 verdict, gets an easily absorbed slap on the wrist for having turned a repeated blind eye to a repeated sexual predator. Now, her lawyer's trying to challenge the constitutionality of this cap before the Ohio Supreme Court, but it looks like it will be an unsuccessful legal challenge. And indeed, when there was public outcry about this case and people realized the fundamental injustice of depriving sexual assault victims of recovery, which is basically what the cap does, 38 members of the Ohio legislature, all Democrats, sponsored a bill to try to repeal the cap for sexual assault victims. Not a single Republican member of the legislature would even co-sponsor such a bill, and it died. It never even got to a vote, which shows that undoing tort deform is going to be a very daunting task. Not only in Ohio, but in other states, sexual assault victims are adversely affected by caps. They have great difficulty in even finding lawyers who will take their cases because the cap works as a virtual ceiling on recovery. And of course, it costs money to bring lawsuits. Other victims of sexually related or reproductive injuries face similar types of problems. I mean, consider a woman who undergoes what turns out to be a completely unnecessary hysterectomy, perhaps through a misdiagnosis. Well, in that case, again, it doesn't keep her out of work. The medical costs will be there, but relatively modest. And for a lifelong deprivation of her reproductive capacity, the jury will put almost all of the damages in the non-economic category, and they will be capped. So that's a whole other category of harm, reproductive harm, much gynecological malpractice, basically slams the door to the civil justice system to people with those types of injuries. Another type of case seriously affected by caps is elder abuse and nursing home negligence. I mean, we've heard other speakers address this problem earlier today. The patient who is ignored and the bed sores are left to fester, causing excruciating pain and diminished life capacity. The mix-up of medications that may, completely scramble the brain and take someone who did have good mental functioning and ruin it. All these types of cases, juries tend to compensate them through non-economic loss damages. After all, the person is elderly. They're in a nursing home. Their working days are past. They're not incurring lost wages. So to the extent that the jury can compensate them at all for their serious pain and deprivation of quality of life, it's all through the fount of damages that are capped by tort deform laws. So what in fact then happens is lawyers no longer are even willing to accept such cases. And as a study of the impact of Texas's caps revealed, the amount of claims in this area of litigation so drastically dried up that many nursing homes now reduce their insurance coverage to the amount of the cap, to $250,000, and laid off their risk management staff. Without lawsuits, what do you need to manage your risk for? And this, of course, the lack of claims, the lack of serious risk management attention within the nursing homes, obviously leads to adverse impacts on patient outcomes and undermines the deterrent value of tort law, a very important value to our society. Similar problems in medical malpractice cases in general. We've heard about their importance from our previous speaker. In cap states, studies of how lawyers have actually dealt with the cap say that on the defense side, lawyers have seen their business dry up and they've turned to other areas of law. But on the plaintiff side, lawyer after lawyer in a cap state says basically they can now only afford to take a medical malpractice case for wealthy people for whom the injury caused by the malpractice will lead to long-term periods out of work, therefore with high economic loss damages, the type that is not capped. Because these are very expensive cases to bring. The expert costs alone could overwhelm the amount of the cap. So they have to leave on the table very meritorious claims with admitted negligence, obvious causation, very serious medical error, and serious injury, just because the plaintiff isn't wealthy, and most of their damages will be in the non-economic category. This certainly distorts or deforms the civil justice system and causes severe inequities in access to the system. Now, one wishes, you could say, that the reduction in claims and the reduction in cases and the laying off of risk management staff means a reduction in actual risk or actual unsafe practices. But unfortunately, research shows quite the opposite. Recent extensive research studies by a group of both law professors and economists looked at states that passed medical malpractice caps in the early 2000s, looked at their rates of adverse medical incidents prior to the cap, after the cap, and then compared it to states that didn't have a cap. And this research showed that in states with the capped recovery in medical malpractice cases, the amount of unsafe care and adverse incidents actually increased from before the cap and in comparison to states without caps. There was more medical malpractice and more bad outcomes for patients. In fact, the conclusion from this study is very important, and I will read it verbatim. We find evidence that the reduced risk of medical malpractice litigation due to state adoption of damages caps leads to higher rates of preventable adverse patient safety events in hospitals. Reduction of litigation leads to higher rates of preventable bad outcomes. That clearly is a harm to society from tort deform. This research also found that, in fact, physician costs, they compared physician rates under Medicare Part B in capped states to non-capped states, and found that physician costs actually increased with the caps, which is very ironic because another supposed selling point for caps that the lobbyists pushed on legislatures was that they would reduce healthcare costs. Of course, they had no evidence for that proposition at the time, and unfortunately now we have evidence that the caps can ironically actually increase physician costs. So, tort deform in the medical malpractice area harms us all by tilting the civil justice system access towards the wealthy and increasing preventable adverse outcomes and diminishing the quality of care and increasing costs. Now, another area in which tort deform causes serious problems for particular types of injured people and for all of us is cases malpractice where the person injured by the medical malpractice is an infant or a child. I did extensive research on California cases. California was the first state to adopt a medical malpractice cap all the way back in 1975. So I had decades of jury verdicts, and I read through hundreds and hundreds of cases to see how juries actually allocated the damages in different types of injuries. By the way, in cap states, the juries don't get told there's a cap. So they award what they think is fair for the injured person, and then the judge has to come along and impose the cap legislation. So what I found is that in malpractice, in pediatric malpractice cases, when the baby or the child survives, they have years of extensive medical bills, so the economic uncapped damages are very high. But in cases where the baby or child dies as a result of the malpractice, the medical bills get cut off. And the juries tend to award 97% of the total compensation in such cases in the non-economic loss category, the capped category. So the impact of the cap is to reduce the overall compensation in these cases to virtually the amount of the cap. And predictably, what happened in California is what I reported about in Texas. Lawyers stopped being unable to simply afford to bring these very complex, very expensive medical malpractice cases. Indeed, I uncovered incidents of parents who had pursued a claim with a lawyer while the child was still lingering still alive from the malpractice, and the minute the child died, the lawyer said, "I'm very sorry, the case just is no longer viable to pursue." So the medical error goes undeterred and unredressed. In fact, the overall conclusion of my research was that I call women, children, and the elderly the hidden victims of tort reform, the primary evidence of tort deform. So in conclusion, these scenarios, well, they're not just hypothetical scenarios, they're real cases, I think illustrate just a few of the many ways in which so-called tort reform actually has deformed, distorted the system in ways that harm us all. Reduces the deterrence of preventable injuries. It closes off access to the civil justice system to people, not because they don't have a meritorious case, or not because they don't have a serious injury, but instead because they've suffered a type of harm that gets compensated through non-economic damages, or because they're too old, because they're too young, because they're too female, or because they're too poor. And when you add all of this up, we now have a very deformed, very unfair system of biased access to the civil justice system and free rein on continuing to commit injuries and malpractice on the part of parties for whom the injuries could very easily be prevented. So truly, tort reform is tort deform, and it harms us all by undermining the important social functions of the tort system. Thank you very much.